Welcome to Deals and Disputes with the Webb Law Group.
Hello and welcome to today's episode of Deals and Disputes with Webb, Allbritton, and Gentry, where we explore some of the most pressing legal challenges of our time. I am joined today by Gaines West. Gaines, thanks so much for being here.
Welcome. I'm enjoying being here.
Today we're going to talk about defending an attorney professional discipline case. So let's just start here. How long have you been working in the attorney grievance system?
I've been in the attorney grievance system for about 35 of my 50 years of practice. In 1992, I was initially appointed by the Texas Supreme Court to the Board of Disciplinary Appeals. I served there for 11 years, and then after retiring from that volunteer work with the bar, I was appointed by the Texas Supreme Court to the Grievance Oversight Committee, which is a committee that looks at the system and makes recommendations to the Supreme Court. And it's our Texas Supreme Court who monitors and is responsible for the delivery of grievance work and holding attorneys accountable for their actions. So I was on that committee, the Grievance Oversight Committee, for 6 years. I chaired the Board of Disciplinary Appeals in my last couple of years, and then I chaired the Grievance Oversight Committee. In my last couple of years on that committee, I retired from volunteer service in 2010 and began representing attorneys, judges, and complainants in the system. So it's kind of almost equal, 17 years on the volunteer side with the bar. And then for the last 15 years, I've been working with attorneys and judges and complainants in our grievance system.
That's interesting, being on both sides of that, the attorneys and judges, and then also the complainants. What kind of a perspective have you gained because you've had experience on both sides?
It's a great perspective. You really don't understand or know the nuances, or I call them the cracks or the wrinkles in the system, unless you've been on both sides of it. So I've really enjoyed the development of the knowledge and experience over the years. We've also had more rules in the grievance system roll out in the last few years than we had in the previous 30 years.
Oh, wow.
So it's a rapidly changing area, and one that requires, constant updating. And it's a great challenge, though. I really love it. I love to help people. I love to help attorneys. I love to help complainants in the system because, a strong attorney grievance system is the hallmark of the public having the trust in their attorney, so that they know if there's a potential problem of an attorney falling below his or her required actions that are just by rules of professional conduct require, there is a mechanism that they can avail themselves of that is free of charge to them to be able to bring a complaint and have the bar review it. Mm-hmm. I really have been pressing our Bar Association to be very active in their changes of our rules so that we have something that is equally applied to all attorneys. And that's, important in any fair system. So I'm working now, of course, on the attorney side mostly, but for some complainants to be sure that our system is meted out fairly and equally.
Well, I commend you for doing volunteer work, because did you just feel like you had too much free time on your hands? Was that the problem?
I didn't have any free time. As a matter of fact, I spent many weekends and weeknights reading grievances and making sure that the volunteer side of the system ran as smoothly as it could. Learned so very much in all those years. And now I've been able to put that to practice, representing clients in the attorney grievance system. Plus, I will say, too, I work now as an expert witness in the area of attorney malpractice on both sides, whether it's from the plaintiff side or the defense side. And all of my experience in the grievance defense work, both volunteer and in representing attorneys and complainants, has come in very handy. It doesn't mean that if you fall below the standard of care in the attorney grievance system that that's automatically malpractice, but it can be a harbinger of issues that need to be discussed in an attorney malpractice scene. So much of my experience now, not only in defending and prosecuting claims in the grievance system, is also used in attorney malpractice areas.
What are the most common grievances that you see?
Over the years, the most common grievance that is filed is that the attorney has not communicated adequately with their client. Attorneys get very busy, and the cases they're working on today may be swept away by more challenging cases tomorrow. But we have to remember as professionals and as attorneys representing our clients, that case may not be the most important one, or the most pressing one on my desk. It is for that client. And so we need to always remember to stay in contact. Some of the most interesting, grievances that I've been involved in have dealt with the attorney who may want to pass off that responsibility to someone else, like a paralegal or their legal assistant, to communicate. And sometimes that works, but for the most part, it doesn't. The client came in to have you represent them, and they want to hear from you. And, this always creates a real problem when you're about to leave on vacation, if you ever take one. And if, you're about to head out the door, and it just seems like those clients have a sense when you're going to leave, and they just need to talk to you. Yeah. And that frustration comes with you've got a plane to catch or a boat to get on or whatever it is. And there's, you just got so much time that you can spend. But it's important when the going gets rough, you need to get tough in terms of being sure that you are communicating with your client. You can even get ahead of it and say, I'm going to be out for a week. Let's just, cover a few things before I go. It goes a long way.
Absolutely.
For the client happiness, if you'll keep them plugged in. But still, the number one grievance is going to be failure to adequately keep the client informed. And we find there's 3 top areas that still receive the most grievances, and that's criminal defense work that just perennially provides a lot of concern for criminal defense lawyers. We have PI work or personal injury work, and we have family law. Those areas seem to provide the most challenge for attorneys in those areas. But it's not to say that there's other areas that don't get a look from clients as well. The grievances can vary so much. The area of conflict of laws or the conflicts that we as attorneys have to deal with has garnered a great deal of attention in the last few years, and rule changes. So the issues that I deal with for attorneys and when they have grievances filed against them just go the full gamut. I can give you stories that you would say were science fiction, but they're really not. And I've seen and kind of heard them all.
I believe you. And you brought up a really good point too about the communication, because it's sometimes hard to remember in a lot of different service industries. You have a lot of different clients, but that each one of those clients, that's like their focus. That is everything they're thinking about. It's all they're thinking about, especially if it's a criminal case. It's just, taking over their mind. But yet you've got, the lawyer has multiple cases that they're dealing with. And so they don't have that connection to it, the same kind of connection, I should say. So the being proactive about communication is probably the number one thing you can do, huh?
It really is. And the challenge is to make sure that client understands that while you have other work to do, that this is an important case for you. And you communicate that regularly and do it yourself. That makes a big, big difference.
So what's the first thing you recommend a lawyer do when they find that a grievance has been filed against them?
Oftentimes they feel like they can handle it themselves. And I give them all the best opportunities to do that. But what I've found is attorneys very often don't really understand our grievance system. And it kind of messes their mind over because, we're attorneys and we're supposed to know everything about the law and someone files a grievance against you, and it's emotional. I mean, it's very emotional for that lawyer.
Yeah, it's kind of a personal. It's personal. Yeah,
It's very personal.
yeah.
And so what I've found is that those lawyers who will understand that, this is something that I don't need to deal with, I need to hire somebody to deal with it for me, is really, really, really smart in being able to do it. Now, I'm not trying to drum up business for myself. Thankfully, I have plenty of business. But I would tell the lawyers, I tell my clients as lawyers, I say, you're some of the worst clients I have, because as an attorney, you think you know everything, you think you know what to do and when to do it. But in this area of attorney defense and the grievance system, they really don't. And it takes years of practice and experience to understand, the opportunities that you can avail yourself of in this process. But I would say the worst thing they can do is just say, look, I'm going to just treat this like any other case. I'm going to represent myself and I'm going to go forward and crush this. They usually don't crush it. They usually get crushed. So I think the first thing would be to examine, really, what am I doing if I'm going to continue to represent myself in a system that I really don't understand and haven't been involved in? So I would suggest to them that they need to get representation.
Yeah, and to your point about not, they're an expert in their field of law, but all of a sudden trying to defend themselves because it is personal, and maybe they're like, oh, I'm defending myself because I know this is a bunch of BS or whatever. But
not only that, it's a bit embarrassing to them,
yeah,
that they're having to deal with it, and then to have to call someone up and actually pay them money to represent them is, sometimes it's very difficult. Now, one of the good things is that a lot of attorneys have malpractice insurance, and many of malpractice insurers will have a pot of money that they will allow you to use to defend yourself in a grievance. They normally then will also let you choose your attorney, and they just reimburse you up to a certain amount. So there are ways to get that funded. And plus, in my grievance work, I discount my fee some off my regular litigation fee, because I'm trying to stretch those legal dollars, because oftentimes it comes out of the attorney's back pocket. So that's my desire, is to make it as easy as I can to explain it in all of my representations, whether it's this area or any area. My goal is to have the client make informed decisions, because those are going to be the best decisions because they fit that client. So my desire is to make sure they understand what their points of choice are, and that they fully understand their options, so that when they make a decision and they look back on it months, even years, they can say, I made the right decision for the time.
Can you briefly walk us through the process? So someone hires you because they've had a grievance against them. How does it all unfold?
Sure. When a lawyer gets a grievance, they normally get a letter from the Chief Disciplinary Counsel, which is the lawyer that the bar hires to prosecute the grievance. It requires the lawyer to respond within a period of time, normally 30 days. Generally, we can get that extended by another 30 days. And they have decisions, though, immediately, because not long ago, they've allowed the attorney to appeal a grievance to say it didn't really state a grievance at all, and they can appeal that to the Board of Disciplinary Appeals. We used to do that years ago. Now it's come back. Another decision point early on for the attorney is to decide whether the person who's making the grievance has standing to make the grievance. That's brand new, too, within the last several years. So that the person who is bringing the grievance has to have some relationship to the issue. It used to be for, over 30 years in the grievance system that you didn't have to have any special relationship to bring a grievance. Just anybody could bring a grievance. That's not true anymore. So there's some early decision points that need to be made. So that lawyer, when he or she gets that grievance, doesn't need to tarry long. They need to get help or school themselves up on what they need to do. It proceeds then through a triage of decisions from the Chief Disciplinary Counsel to determine whether or not that grievance is going to be upgraded to a complaint, and whether there is just cause that will make the grievance go forward in the system. The attorney with the Chief Disciplinary Counsel's office and his or her investigator can make a decision on their own that there's just cause, or they can decide that they're going to send it to what's called the Summary Disposition Panel. The acronym is SDP, to dismiss the case, or they can send it to the IVH, the Investigatory Hearing Panel, to make a determination of just cause. So that triage really is a three-way decision point that has to be made. We generally, when we help someone respond to a grievance, we're trying to be as thorough and complete as possible to encourage the Chief Disciplinary Counsel lawyer to make a decision to send that grievance to the Summary Disposition Panel. If that doesn't happen and we go to an investigatory hearing for just cause, then we appear with our client. If just cause is found, then the election letter is sent out for the lawyer to decide to go either an administrative route through the evidentiary panel or to district court, just like any other lawsuit. And that's where the two arms of this separate. If you go through an evidentiary panel, you'll get a panel usually of a couple of lawyers and one or two public members. And if you don't like that result, you appeal it to the Board of Disciplinary Appeals onto the Supreme Court of Texas. If you select the district court route, then you have an actual trial and you can have a jury and you can appeal any result there to the regular appellate court that we find in our regular judicial system, and then on to the Supreme Court after that. So it can be quite a lengthy process, and it can be an expensive process. So that's why it's really, really very helpful to get on top of this early and decide exactly how you're going to handle this.
And the complainants, they're looking for money back from what they paid?
No, as a matter of fact, getting money back is normally not one of the things that they can get out of the disciplinary rules of professional conduct or the violation for it. What the sanction it can be is anywhere from what we call a grievance referral program, a GRP, to a private reprimand, to all the way up to disbarment. It could be a suspension or any of those kinds of disciplines are available to the bar. And so it's really important for the attorney to understand those ranges of disciplines and what can happen to them. I mean, if it's a private reprimand, it gets published in the Bar Journal without a name. But if it's a suspension, whether it's probated or active suspension, it's going to be put in the Bar Journal, and it's probably likely going to wind up on the front page of your or one of the pages of your community news paper or some of the blogs that people are on. So it can become quite public. One of the other problems is that once you have been adjudged responsible as violating one of the disciplinary rules of professional conduct, then that stays with you on your bar page, your identification page with the bar, for the remainder of your career. We can't take it off. We used to be able to petition to get it off, but we can't get it off anymore. So that's a big problem. That should show you the necessity for that attorney when they get that grievance to really size it up in a hurry and make decisions. So because it can have a real long-lasting impact on your license.
No doubt. No doubt. Well, thank you for tuning in to Deals and Disputes with West, Webb, Allbritton, and Gentry. To connect with Gaines and the team, visit westweblaw.com, and that is Webb with 2 B's. And also, please like and subscribe to our channel. We love having you be part of our community. Gaines, really enjoyed the conversation. Thanks so much for the insight on a topic that is not known to most people.
Thank you. I enjoyed doing it. And, I think the main thing that I want the viewer to take away with them is to know that if they ever get that grievance filed, they need to reach out and get some good, solid, sound advice. Otherwise, they could be in for a real mess.
Absolutely. All right. Well, thanks again, Gaines.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.